Hi there, Assalamualaikum. My name is Fatullah Hazim Fuzani. As a leader in this report study case, my job is identify who is the plaintiff and who is the defendant. Permit to extraction and removal of rock material. It is a permit whereby the holder can do extraction, removal and transportation of any rock material, but it is unable to issue for obtaining metal and mineral, and also the purpose for mining, removal of forest produce. They are also have the terms and the condition that the holder must give cooperation. In this case study, the main topic is about whether the additional permit is required to transport the processed sand, and what if the sand transported by the third party. This case is using the section 15, 72 and section 426 according to NLC. So in this study case, the plaintiff is Lim Cow and Core Mineral Sdn Bhd, and the defendant is the pentadbir tanah daerah Gombak.
Assalamualaikum, my name is Abdul Muiz bin Jahani, ID number is 20204-72728. I would like to present the facts of the case. The case is about permit to extract rock materials. In November 1990, the Gombak Land Authorities grant a concession under Section 72 of the National Land Code 1965 to remove rock materials to 1 TTC. The permission allowed the permit holder to harvest only sand from lot 1818 and also identified 13 vehicle numbers that were authorized to carry the material, including lorry number WTX528. The plaintiff facility processed the raw sand for sale to MSG, a glass manufacturing company. By vehicle, the processed sand was delivered to the MSG facility in plastic bags. The mentioned vehicle was stopped and held by authorities on November 28, 1990. While transporting processed sand, since the truck driver was unable to show a permit in line with Section 426 of the National Land Code. On November 29, 1990, lorry number WAW2506 was held in a similar manner. 1L and 1H were the owner of the vehicles. The plaintiff filed these ex parte actions to secure a release of Boost Truck as the owner of the items on lorry number X528. The court had to decide whether the plaintiff need another permission to carry complete product to its client on rented transport, after legitimately acquiring raw sand from third parties and processing it at its facility.
Assalamualaikum, my name is Nusha Vika binti Arifin, and my responsibility in this group assignment is to explain plaintiff argument. Firstly, the plaintiff processed the raw sand on his factory for subsequent sale to MSG, a glass making factory. The processed sand was sent in plastic bags to the MSG factory promised by lorry. Then the plaintiff, as owner of the goods on lorry number 8528, failed this ex parte proceeding to obtain a release of both lorry. Ex parte is used to refer to motion for orders that can be granted without waiting for a response from the other side. Then, the issue for the court was whether having lawfully acquired raw sand from the third party and the process the same at its factory, the plaintiff required another permit to transfer the finished products to its customer on hire transport. Lorry WW82506 was detained at Kuang Police Station pending further investigation by Insyad Kamaruzzaman bin Ahmad, a pegawai penempatan tanah daerah Gombak at Simpang 4 Batu 18, because the lorry driver was unable to produce any permit in accordance with Section 426 of the National Land Code. Same issue as the lorry that Insyad Adnan bin Arif, the Inspector Director Officer Daerah Gombak, stopped which is lorry WT528 on the Kudang Kuang Road. It was loaded with sand packed in plastic bags from the applicant factory for MSD. It is alleged the lorry driver was unable to produce a permit according with Section 426 of the National Land Code. He therefore had the lorry detained at Kudang Police Station for further investigation. The registered owner of the lorry WT8528 is Limco and Honor. TA Limrose Construction Co. Lorry WAW2506 is owned by Hexagon Tower Sendirian Berhad. Next, the plaintiff referred the matter to their solicitors who were unable to obtain the release of the lorry. These proceedings were therefore filed on 31 January 1991 ex parte. In the affidavit in support of this application, the plaintiff asserted that the lorry were permitted to transfer the material found thereon by virtue of the permit issued under Section 72 of the National Land Code to Tan Tek Chong on 2 November 1919. Lastly, in the oral submission before the plaintiff, counsel submitted that the detention of this lorry was an abuse of authority and in addition to an order for their release, also asked for an order for the match. The plaintiff counsel also countered that SAPS was collecting royalty from the plaintiff for all processed sand coming out of the factory.
Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Iman Najiha binti Sahjihan and my matric number is 2020821506 and my responsibility is defendant's argument. Defendant's arguments. The plaintiff don't own either one of the lorries, but the plaintiff had the goods on the lorries they had hired to transport the processed sand. Under the Selangor Land Rules 1966R22, a royalty of RM4 per cubic yard had to be paid for this permit. It is not suggested that the delivery by Tan Tek Sang of the raw material to the plaintiff's factory was not a lawful activity. Once the material got there, it is evident that the plaintiff acquired a legitimate interest in the material which they processed and packed for transportations to MSG. With the greatest respect to the defendant and to Salahuddin, I am unable to agree that this required yet another permit under S72 of the NLC. I say so because the plaintiff was not extracting, removing and transporting rock material from state land, because that had already been done by someone else who had paid for the privilege. For the sake of clarity, I will emphasize that there was no question of extraction and removal in the factory. Consequently, it is clear to this court that the defendant and his officers have acted under a misapprehension. In the present case, there are many shortcomings in the manner in which the plaintiff has framed its case. They do not own either of the lorries. Limco and Anor is not the plaintiff. Neither lorry owner is before me, but the plaintiff owned the goods on the lorries they had hired to transport the processed sand and thereby put the lorry owners in peril. This originating summons was filed well within the 3 months period provided by S418 of the NLC. In the interest of justice, I am treating these proceedings as an appeal under that section. The only order which I need to make in these proceedings is that both the lorry be released forthwith to the owners and the goods thereon be released to the plaintiff, because on the uncontested facts, the issue of unauthorized detentions is the only one I can safely decide. What is to happen to the magistrate's court summons at Rawang arising out of this case, and whether any action is to be taken for unauthorized occupations of state land by SAPS are matters which have to be dealt with elsewhere. So also the claim made for damage by the plaintiff counsel, which is based on contest facts which are more properly a matter for a civil action in the proper court. It does seem that the defendant acts in good faith, and the extent to which that would go in defense or mitigations is also not a matter for me now. The plaintiff must be paid the cost of these applications by the defendant.
Assalamualaikum, my name is Natasha Safar binti Muhammad Nazri. My part in this report is the court decision. The court decided that the plaintiff are not guilty as they acquires a legitimate interest in materials that they process and pack to be brought to Malaysia Ship Class Berhad (MSG). This is because the plaintiff was also not involved in the extracting, removing and transporting the rock material. It is clear that the defendant and his officers have acted under a misapprehension. Therefore, the only order made by the court was both the lorries be released to the owners and the goods released to the plaintiff. The defendant must also pay the cost of the application for the plaintiff.